Good morning, everyone, or I guess it's good afternoon. My name is Merritt Green. I'm the founder, managing partner of General Counsel PC. Thank you for being here today for our 20 estate planning questions. And thank you, Anne Marie, for being here to be our expert.
And thank you for having me.
So as we go through today, what this is we're going through 20 questions. And these are 20 questions that, you know, as Anne Marie has practiced estate planning over the last several years, the most common questions that a lot of her clients would have. And we think it's a great introduction to estate planning, and hopefully it's helpful for you. As we go through this, you have the questions tab that is available in the GoToWebinar toolbox. Go ahead, ask any questions. You know, if we spend this whole time asking and answering questions, that would be a great use of time also, even if we don't get through the whole presentation. So please use the questions tab to ask any questions that you may have. So with that, let's go ahead and get going. Just quickly, an overview of General Counsel. The firm was founded in 2004. We serve as legal counsel to businesses, nonprofits, and individuals throughout the Washington, D.C. area. We are headquartered here in McLean, Virginia, but we represent clients throughout the area, and we actually represent clients throughout the country. So we have 6 primary practice areas. So we really do serve as the outside general counsel to businesses and nonprofits. So in that regard, we're doing corporate and M&A work, business contracts and the like. We're doing labor and employment law issues on a day-to-day basis, hiring, firing, non-compete, non-solicitation agreements. We're spending more time than you could possibly imagine on vaccine mandate issues now. So we're really doing a lot in that regard. We have a government contracts practice. We have a strong litigation dispute resolution practice that's handling arbitration and litigation matters throughout the area. We have a family law practice. And then, of course, as we're going to talk about today, we have an estate planning business succession practice. With that, you know, Anne Marie, do you want to give a little bit of your own introduction and background?
Yeah, absolutely. First, I wanted to echo what you said. Thank you very much for joining us. It's great that you're open to this conversation about estate planning. Some people don't even want to talk about it. So the fact you're even on here listening is a credit to you, that you want to protect yourself and protect your loved ones. So thank you again for joining us. And for those who signed up already for the free consultation, just wanted to say looking forward to speaking with you, and wanted to just put that out to you again. If you missed that when you registered, as part of the webinar, we're offering free consultations, and so that information should be in your webinar registration form. So yes, I do estate planning, which involves wills, trusts, a combination of all of that, and overview of your finances and how your assets can be held if and when anything happens to you, and when you pass away, you can designate where your assets will go. But also, as part of GCPC, we advise businesses to create a game plan or a battle plan if anything happens to them. We call that business contingency planning. So we can set up almost like a estate plan for your business. And the third thing we do as well is business succession planning, which is handing your business down to the next person when you are no longer able to run it. So those are 3 aspects. Oh, and probate and estate administration, right? That's the other issue. So
Exactly.
Go ahead.
Nope. You want to give a little more of your background, or ready to go?
Yeah, let's just jump right in.
All right. So here, you know, this is just a lot of people love Anne Marie and a lot of satisfied clients, but we don't need to read through that. And then here we have the question number 1. So question number 1, I don't have an estate. Why do I need estate planning? What does estate planning mean? It sounds something that's really fancy, and you have to be in England and own an estate with a castle.
Yes, and no, that's definitely not what estate planning is, but it is what most people think. But even if you just have a condo, or you own just a home, and if you have just a small amount of money in a bank account and a retirement account, you may consider having an estate plan, because an estate plan is necessary to determine what's going to happen with your assets, and also what's going to happen with your body when you pass away. And best practices also advise that you have a plan in case you're incapacitated. So what could happen, now we're in the age of the pandemic and COVID, people are in the hospital for longer periods of time unexpectedly. What happens to your assets when that happens, or what happens to your business when you're not able to run it? So your estate plan can incorporate that aspect as well.
It almost seems that what would be better, instead of calling it estate planning, we should try to call it life planning or something along those lines. Although that sort of sounds a little hokey also, but it's really taking control of your own life and what happens not only while you're alive, but also, if you're disabled, incapacitated in some manner, or you pass away. It's what happens to your property, what happens to your children, what happens to your finances, whether after you pass away or during your lifetime, and then also what happens with your health care. If you don't have a plan, and we'll talk about this more,
one big issue that people are more aware of now is they'd rather not have the government make decisions for them or a court make decisions for them. They want to make their own decisions, whether it's healthcare related or to their finances. And you don't want to pay more money in taxes or to the government than you have to. You'd rather keep your hard-earned money within your family. And if that's the case, if that's the type of person that you are, then estate planning is the right thing for you to do.
Mm-hmm. Yeah, absolutely. So, I know we're going to talk about some of these a little bit more in detail, but what are the most common tools that are used in this estate plan?
Well, most everybody knows about a will. A will is the age-old way to transfer your assets to your loved ones or to give to a charity, etc. But a will is instructions to a court about what you want to happen when you pass away. It only is effective when you die. And then there is a trust, and sometimes you hear it referred to as a living trust, and that really is to designate that can operate during your lifetime as well as when you are incapacitated and pass away. So that's one of the main differences there. But also, you hear me mention the power of attorney, an advanced healthcare directive, also called a living will, and a privacy waiver, as well as the ability to nominate guardians for minors, whether on a temporary or permanent basis. Those are also tools commonly used in estate planning.
Excellent. And then number 3 is, what is probate and why should I care?
Well, I sort of alluded to this earlier, but if you have a will, then the will go to probate, which is an administrative procedure where a judge looks at the will and interprets it, and it marshals all the assets and then uses an executor to distribute out your assets to the beneficiaries as you indicated. If you don't have a will, then your assets will also go through probate through this administrative procedure. And what people often don't know about a probate is, first of all, it's public. So anything that goes through probate is public and is not shielded. So if you're concerned about your privacy, then you may want to avoid probate. The second downside of probate is you do have to pay an attorney by the hour, and attorneys' rates, range from $350 to $850 by the hour to manage or more, right? And there are a lot of delays. All the assets going through probate are frozen until a decision can be made and a court orders what should be done with your property. So in that meantime, everything is held in limbo. So probate, like most court procedures, is not ideal. But then again, if that's something that you want to plan for ahead of time, you can use a power of attorney to handle the issues when you're incapacitated. So there are ways to work around it. Having a will is not terrible because having a plan is better than no plan.
How long does probate normally take? How long, you imagine a family with, the person dies intestate, meaning they don't have a will, with $1 million, 3 kids who could probably use that money. How long does that generally take?
Yeah, it usually takes between 4 and 6 months. The good news is during the pandemic, like most of us, the courts had to pivot a little bit to become more flexible and allow more online access and uploading documents versus formally filing it through the clerk's office. So they have gotten more efficient, but that has slowed down the procedure. And of course, with more people passing away, obviously they're overloaded themselves. So it really is still 4 to 6 months, even though they're more efficient and it's more streamlined.
Gotcha. All right, let's go on to question number 4, which is, what is a medical?
I was just going to say, it's funny, I don't remember what questions are on the slide, so it's all very fresh to me.
Excellent. What is a medical directive, and why do I need one? It's just like you were in an actual client meeting and you don't know what the client's going to be asking.
Exactly, which is good. I like it that way. So a medical directive is a way to write down what type of medical care you want or that you don't want. So if you don't want antibiotics, for example, or if you don't want a vaccine, or you don't want something happen, or you don't want life-sustaining treatment, or on the other flip side, if you do want CPR, if you do want extraordinary care or pain medication, you can specify that. And then this medical directive is only in effect if you can't communicate yourself. So if you can't blink your eyes for yes and no, if you can't communicate at all, then they will rely on this medical directive. And what it does, it actually relieves stress of your family to try to guess what you would want in different scenarios. And the way we do it is very customized. We have different hypotheticals and we go through those with you. And we'll say, in this scenario, what would you want? And that is giving guidance to the person who stands in your shoes when you can't express that yourself. And they can say, look, attending doctor, attending physician, this is what they would want. I have it written here. It's notarized. We went through this, and then they would follow your directives.
Mm-hmm. Yeah, I think that's where we sort of get into that the estate planning, terminology is almost a little deceptive, because anyone, and everyone should have a medical directive. Even if you're, 20 years old and a freshman in college, it might be good to have a medical directive. If you don't believe in, being alive on, on feeding tubes or whatever else, it could be life support. You may want to have that medical directive in place. And because even if your parents in this scenario know what you want, they may not be able to force a hospital to take you off life support. And that's, obviously a situation that you want to avoid.
Yeah, you're absolutely right. And that does happen, when the young people turn 18, there are adults in their own right and they have their own rights, and parents can recommend things. But, if it's not written down what someone wants, even if they're 18, 19, 20, it's only recommendation. You are their parents, but they would make their own wishes known.
Yeah.
And this happens a lot now, during COVID. We have these ECMO machines, for example, that take your blood out, recirculate it, have oxygen, and then put it back in. And you actually have to be put under a coma to have some of this treatment, medically induced coma. And is that something that you would want or not want? And when you're in there, how long should you be in a coma? How long? And another issue that comes up is for pain medication. Most people would want pain medication in certain situations, but there are indications, sometimes for certain pain medication that actually impacts the organs to a negative way. So it could actually damage the liver, for example. And so would you want pain medication in that situation, or would you only want it when it wouldn't damage your organs? So these are nuances that you can address ahead of time in the advanced medical directive.
Absolutely. All right, well, let's move it on. What's the power of an attorney and why is it important? And I guess, why is it important not only to an individual, but perhaps also that business owner?
Yeah. So a power of attorney allows someone else, usually another trusted advisor or a family member or a friend, but it could also be a law firm, to stand in your shoes if you can't manage your finances for whatever reason. So for example, you could use it out of convenience. You could name someone, a husband could name his wife or vice versa, to have access to their financial accounts or online accounts or whatever you want to provide access to. It can be customized. So if you happen to go away on a girls' vacation and your husband wants to do something with your accounts and needs your signature, he can simply bring the power of attorney to the bank, and that could all be done. But a more critical way to look at a power of attorney is if you're incapacitated, you're giving someone else the power over your affairs, that they could manage them when you are not able to. So it's similar to a medical directive in that respect, but it applies to your financial accounts and your online accounts, social media, etc. As it relates to a business owner, it's very critical. It would allow one of your officers or a trusted employee to make decisions when you cannot for your business. And sometimes that happens. Sometimes you can't run your business and you need to rely on someone else, and you can make that very customized. It doesn't have to just be a form that's downloaded from the internet. You can specifically go through your business operations and explain what you would want to happen in case of emergency and what your values are.
I know for one client recently, we actually put together a committee. So if the business owner was incapacitated in some manner, there would be a committee, I think it was of 3 people, who would be in charge of making decisions and helping run the organization. And that's important because the company otherwise could grind to a halt, and if it's worth $5 million, it could become valueless because no one's there to make decisions.
Yeah, and you wouldn't want to give an opportunity to your competitors to just swoop in and take your spot when you can still have the business run smoothly if you happen to be out for 30 days, 60 days. Or let's just imagine if you're shut out of the country and you can't sign a certain contract, and you didn't designate someone to sign on your behalf ahead of time because you got a negative COVID test or for whatever reason. So there's a lot of different scenarios. If you just do a little planning ahead of time, it would take 2 to 3 hours maximum to do a customized power of attorney. You're saving yourself so many legal fees and so much time and stress.
No, absolutely. And it can be, as you said, customized. So some of them are going to be springing powers of attorney. So it only comes into play upon the, incapacity, or deals with other scenarios and like that. All right, moving on. What is the difference between a will and a trust?
So I alluded to this a little bit earlier. I'm going to try to explain it in a different way in case it didn't resonate with everyone. But a will is written instructions about what you want done with your assets. And sometimes it includes also what you done with your body, how taxes are paid and debts are paid. Whereas a trust is different. It actually is in effect during your lifetime. It can include specific conditions about when different assets can be given to different people. It can be private, so only your trustee has information about that. And it can also be an important financial structure to avoid taxes.
Isn't one of the other differences that a will generally takes effect upon death, whereas a trust takes, occurs during the lifetime?
Mm-hmm. Yep, absolutely. And to make it a little bit more complicated, because I'm sure people who signed on probably already have a little bit of a grasp of estate planning, sometimes a will can contain a trust in it. And so what I'm saying there is there's a testamentary trust. So if certain conditions are met, the will can ask a court to create a trust for you. So rather than you creating a trust ahead of time, if certain conditions are met, a judge can create a trust. So for example, if one of your grandchildren or one of your own children has a special needs trust, the judge can say, I see that one child has special needs. Let's create a trust so their assets are placed into a special needs trust for their benefit. So the judge would direct that versus having a trust ahead of time. Mind you, of course, it's
generally better to do it ahead of time, though.
Yeah, because you can make the conditions yourself. You can come up with the different scenarios versus the judge doing it for you. It's always better to handle your own affairs, be in control, right? But that is another way of doing it. And I just wanted to be thorough and full disclosure. You can do it on the front end yourself, or you can have the judge do it on the back end if certain conditions arise.
Although I would imagine that could become even more expensive, is that the judge is probably going to require the estate to hire an attorneys to still draft all the documents, and you probably have more opportunity for dispute and confusion because the person's passed away. So how do you really determine what needs to be done? So,
and also maybe a hearing about, whether those different conditions are met. And if you have any hearing, you're paying for someone by the hour, you need testimony, evidence, blah, blah, blah. So yeah, it's a little bit more involved, but it is a different way of doing it.
yeah, we keep going back to, initially what we talked about. Question number one is what's estate planning? I think you really just have to focus on it's planning. It is planning for the future and the what ifs of life. And some of them are not even what ifs. I guess you can't avoid taxes and death. And that's part of what the estate planning is all about. And then the one other thing about a trust, and I apologize if you said this, it helps you avoid probate. Which is probably one of the biggest reasons to do it. And of course there's also tons of different types of trusts you can do for special needs kids or potentially avoiding taxes. And we'll go into that a little bit more in a few minutes. Question number 7. I heard of a pour over will. What is that?
So a pour over will is usually a document that accompanies a trust. So another way to explain a trust is a box that you can put any of your assets in, and it holds your property or your financial accounts. Sometimes, people have not, for whatever reason, put all their assets into their trust, whether they ran out of time, if they just happened to purchase something, and so they haven't, quote, funded their trust fully. And so a pour over will is really a fail-safe. It's a backup plan. If you haven't funded your trust completely with all your assets, the will says, Judge, I do have a trust. Would you please pour over all the assets that I didn't put in my trust for whatever reason, I just forgot or whatever, into my trust? So that's a very simple will to be probated. That happens all the time. And the judge just executes an order saying, yes, I see that this assets are not in the trust. This is what the testator wanted. I hereby order they go into the trust. So it's really a backup plan.
And it's also just thinking through it practically. You put a lot of your larger assets probably within the trust, the house, maybe certain bank accounts, investment accounts, other things along those lines, but do you ever put sort of all the incidentals of life within a trust also? Your clothes, your collection of, Nancy Drew books, whatever it may be, not that I have a collection of Nancy Drew books. Are those, I guess if they're very valuable, those could be in a trust also. But otherwise, there's just all the miscellany of life. Are those ever put into a trust, or are they generally always going to be part of a pour over will?
No, I think you're right. It is also in best practices to assign them to the trust. So that's a separate document we sign, sorry to say execute, try not to sound too much like a lawyer here, but you assign those personal property items to the trust in a separate document. So you can assign them and then they are funded within the trust. And then in the trust document itself, you can say what each item is going to go to, or you can lump it together. Like all my jewelry is going to go to my niece, Jennifer, and all my tools are going to go to my grandson, Bobby, because he loves tools. So you can have that very specific in your trust if that's what you want. But
Gotcha.
That's another document we execute as part of the whole package of estate planning.
Excellent. All right, well, moving on to question number 8. So, we've been talking about that estate planning is really planning for the future, and if someone is married and has 2 or 3 kids and a house with a mortgage, one of the main reasons they want to do planning is to make sure that their family is financially secure, in the future. Why couldn't I simply why couldn't I simply buy life insurance? Because that's going to get them, let's say, $500,000. That's all they really need.
Yeah, but that's the question. Is that all they really need? first of all, life insurance has beneficiaries named to it. So, if it's a husband-wife situation, then you'd have this large check going to your surviving spouse. And how that person is going to use that money is going to be up to that person. It also won't be shielded for any reason, into any specific fund. You're really relying on your surviving spouse to handle that. And I guess the other overriding issue to that is, if you could just take 2 extra hours or 3 extra hours to do estate planning the right way, then you wouldn't just have this large check looming out there to be spent any way that the person wanted to. You could designate, you can carve out, I guess is the better way you can carve out funds for your children or for your grandchildren to be used in a certain way, and that can reflect your values, whether that's education, setting money aside, seed money if they want to start their own business, if you want to allocate money if and when they have a down payment on a house. You can use your own values or what you would want to give to people through a will or through a trust rather than just through life insurance.
Mm-hmm.
One more nuance on that, I forgot to mention that people often name minors as beneficiaries for life insurance. And if that's the case, that actually gets looped back into probate. It doesn't, it is not acceptable for a minor to receive money through life insurance. So that actually gets dragged out. So if you have it through a will versus in a trust, that's better than life insurance for a minor.
Yeah, that's actually a question I was going to ask. So if life insurance names a spouse as the beneficiary, does that go through probate, or is that independent of probate?
That's independent of probate. Mm-hmm.
Okay, but if minors are named, then it has to go through probate.
Correct, because then the parent, the surviving parent, would have to be nominated to receive it and then give it to the minors, when and if that when they get older.
Okay, and slightly outside the scope of what we're talking about here, and I don't know if we talk about it a little bit later, but you have a lot of blended families, and I know what's happening oftentimes is, in that blended family, someone will buy life insurance and they'll need it to be in a trust because $500,000 goes to the spouse, and maybe $250,000 goes to the child from their first marriage.
Right. Usually to cover, the residence, the mortgage, to make sure they can stay in the home, the former marital home, or to cover for child support, purposes, or for private education or college education. Mm-hmm.
Gotcha. All right. What are some of the benefits of using a trust?
So many. The first one is that you can be very customized about what you want, and you can make sure that if you pass away, when and if you pass away, your money is used the way that you intended it to be used. So, for example, if you pass away and your surviving spouse gets remarried, all of your assets that you gave to that particular spouse don't go to the new family. They can actually be carved out and reserved for your side of the family or for your children, even if someone remarries. Whereas a will, if you pass away and your surviving spouse receives everything that you've given to them, they the next day could will all of your assets, if they wanted, when they died, to the Red Cross or to another family or to whatever
your evil step parent that you just don't like at all, or your evil in-law.
Right. They could give the money whoever they wanted to, but if you have a trust, it's set in stone, it's fixed, and those conditions are only effective based on what you specifically described. Whereas a will, just like life insurance, and life insurance is a good example, you can just change the beneficiary. You can say, oh yeah, I want this person to be a beneficiary, and they're like, oh yes, I'll do that. And then tomorrow they could, fill out a different beneficiary form. It's up to them what they want to do.
So what about this scenario? Husband and wife are married. They don't have a will or a trust of any sort. They haven't seen this webinar and haven't talked to Anne Marie. They are worth, let's say $2 million between house and assets. They get in a car accident, or I often like using, they get hit by a bus. And husband, just, you like to, when you're talking about someone passing away, you almost like to use the scenario that hopefully is not going to happen. You don't hear about people getting hit by buses that often. But so they get hit by a bus and the husband passes away, and the wife is strong and she lives for another 36 hours, and then she passes away. Would the money in that scenario go upon the husband's passing to the wife, and then upon her passing, assuming they have no children, to her family? And in that scenario, if the husband had siblings and parents, they probably wouldn't get a penny?
Yep, that's correct. However, if there is a will, because your scenarios was if they didn't have anything at all, often in wills there's these simultaneous death provisions, which sounds, a little bit morbid, but it basically tries to save families money. If two people died within a period of time, at the same time, you would designate ahead of time which person would be the designated surviving spouse, and then all the assets wouldn't have to go from one to the other and to the family. They could just go designated on what you agree to. So it kind of takes the middle determination out, and there's no court hearing necessary. So you can designate in that stereo who is going to be the surviving spouse and where the funds are going to go.
Yeah, and that's why, again, we really sort of talk about, we're doing planning here. That's the whole goal here. So I had some notes here, benefits of using a trust. Obviously, we talked about you're avoiding probate. There are a lot of techniques to potentially reduce taxes. You can protect the legacy of your family, whether it's keeping money from the evil in-laws or, designate it for charity or otherwise. You have a lot of specific purpose trusts that you can set up, and then also privacy, as we talked about. Quickly, what's the difference between a revocable and an irrevocable trust?
Yeah, that's often people get confused about that. So a revocable trust means that you can, remember I was talking about funding the trust. You can fund the trust. You can put a house, for example, in the trust, and then later you can take the house out of the trust or the finances, the assets in and out as you wish. An irrevocable trust is if you put something in the trust, it stays in the trust for that purpose designated by the trust, and it cannot be taken out. It can only be used for the purposes in that trust. So you're giving up control of your assets. And often when you do that, you get some type of benefit for it. So whether you're getting a government benefit through a Medicaid trust or a special needs trust, that's one option, or you put it in there and you get some type of other financial benefit for it, not related to government benefits.
So, or potentially a tax savings if it's a revocable trust. So you're giving up ownership of the asset, so it's not really part of your taxable estate then upon passing.
Correct.
Okay, interesting. Next question, number 10. I'm single, live in a condo, have some savings and a retirement account. What do I need to do?
So this situation, it's up to you whether you'd want a will or a trust. And we've talked about the benefits of both, but you would want one of those, one or the other. But also you would want to make sure that your savings account has a form which they describe in some of the banks called a POD form, a payable on death form. So if you're holding a savings account just in your own name, you can designate at certain banks who would get that upon your passing. So that's one thing that I would consider. That's, a will or a trust, and then talking to your bank or your financial institution about what forms you can complete if you happen to pass away or when you pass away. And same thing with the retirement account. You have to make sure that your beneficiaries are up to date, and as we mentioned before, not to name minors as beneficiaries to your retirement account, because you don't want that pulled into probate to be managed. And then, of course, if you really want to go and be extra, you could have the power of attorney that we mentioned before, so people can manage your affairs if you happen to be incapacitated. And then that medical directive, that advanced healthcare directive, so you can determine what's going to happen to your body and what medical treatment you're going to receive versus someone else making those decisions for you.
And I would almost think, if it was, this person was a friend of mine or someone I was working with, I would almost say the first thing you want to have is a medical directive. That's almost a no-brainer, because, your savings, I think you can go ahead and, sign the forms. Everyone, when they sign up for a 401k, they're beneficiary forms that you can include. But what you can't do is, you need that medical directive. I would think that's the most important thing for everyone. All right, well, let's keep going then. And we do have some questions here. So why don't I take a second and look at a question or two. So then before we go on to question number 11, Um, Someone asked about destiny planning. Why don't we talk about that in a minute or two when we get into the trust a little bit more.
Mhm.
Next question is, can you update existing trust since all the documentation are resided with the firm that developed the trust?
But usually you keep a copy of it. You can always request a copy of a trust or any type of documents, whether it's litigation or estate plan. You can always get your file from a prior attorney, even if you don't have a copy of it. But yes, it's very common to have amendments to trust. Sometimes it's called a restatement, and that's something that you can do, but you have to usually do that with if it's a joint trust, you have to do it with the person that you jointly own the trust with. So you can't do that separately. And if the trust is in your own name, of course, you can do it on your own. And that's actually one of the common things we're asked to do is to do trust amendments for people. We review their existing estate plans. We tell them where the holes are, where the gaps are. The law changes from the time that someone originally drafted the trust, and we're able to update that with a new amendment and be mindful of best practices for 2021.
What happens if they can't find the trust? It's been lost. And is there a difference between revocable and irrevocable trust and doing amendments?
Well, practically speaking, you'd have to take a step back and see if any assets are held in the name of the trust. So, for example, if a house is held in the name of a trust or a financial account, so it's possible that the real estate agent or the title company would have a copy of the trust because they helped you fund it. So, unlikely it would be completely missing. But even if it is, let's just imagine the hypothetical where it's completely that it's missing. You could still do a restatement and just say what that is. You'll say, I do recall executing a trust on this date. This is what I believe the provisions stated to the best of my recollection, and this is what I want to do now. But first, I would do the step of talking to the title agent or the financial account representative to see if they have a copy, because often they do.
Mm-hmm. Another question is, if your firm develops a trust, how do you get witnesses, as some of the paper required at least 2 witnesses? Mm-hmm. And I could probably answer that as we have 2 paralegals here and an office manager who often are the notaries and witnesses. So that's something that is pretty easy to do.
Mm-hmm.
All right, let's go to question number 11. My husband and I are separated and likely getting divorced. Should I update my will or consider a trust or something else? And in this scenario, so you're assuming that, while married, you did some estate planning, so you and your husband in this scenario, probably have some joint planning that you did together. But you decided that you're probably going to get divorced. What should you do?
Mm-hmm. I hate to sound too much like an attorney and just say it depends, but it just depends if you get along, if this is a situation where you're co-parenting. So those are very specific issues for each family. But I would say overall, see if you have a power of attorney, because if you are separated and you did give a power of attorney to your spouse that you're now divorcing, you may want to revoke that power of attorney. And the same thing for your will, you may want to revoke it. As to the trust, we'd have to look at the specific terms of the trust to see whether it is revocable, irrevocable, right? And if you're holding things jointly or not. So it's one of those situations where you just have to look at how everything is held, how you own it, and then make a decision. But yes, it would be better to update the will sooner than later and get a new power of attorney to someone else that you trust in the meantime.
And I almost think perhaps I have a more negative outlook on these issues, not saying whether or not I ever went through a divorce myself.
Well, I'll say I have.
Scenario, let's say you have life insurance and your life insurance names your current spouse as the beneficiary. You sure as hell want to change that if you're about to go through a divorce, because you don't want to have the scenario where your former spouse gets $1 million upon your death, and then he and his new, or she and her new, 25-year-old, friend move down to, Mexico. And the same thing with a will. I think you absolutely want to do it immediately, because same scenario. You want your money, if something happens to you, to go to your children and even name a trustee who would be, someone other than your ex-spouse. So, when I've seen it done before, you set up a life insurance trust, and your sibling or a friend or someone else is the trustee. So your ex-spouse, who maybe you don't like anymore, doesn't have access to a penny of it.
Yeah, it's very common to actually name people you want to disinherit in your will or your trust. And, it sounds very ominous, but really it's just being clear that these people can't make any claims to your estate or their family. So that way it shuts them out from the whole process, which could slow down, probate, or could slow down the administration of your estate. So you can just say, I was formerly married to X. We were divorced on this date, and this person is not going to be my beneficiary for any of my assets.
No, and even going forward, I mean, we have a family law attorney here, and if you don't have children, there's a 6-month waiting period that you need to be separated. It's a 12-month waiting period that you have to be separated if you do have children. I would, quite honestly, before you even talk to a divorce lawyer, or perhaps simultaneously, you could talk to both Joanne, who's our family law attorney here at General Counsel, and you talk to Anne Marie, who's doing our estate planning. I would talk to them simultaneously, and before you even talk to your spouse about getting divorced and separated, I would consider updating some of these documents. While you are in that 6 or 12-month period of separation, you want to have this planning done. So anyway, that's just me. But it's what would be my strong recommendation. All right, number 12.
But before we go on to, before we go on, I just wanted to mention that Joanna and I would coordinate definitely, if she happens to have a situation where her client is being separated. And we can also incorporate the co-parenting agreement into the estate plan. So for example, if, every Thanksgiving you go usually to, your parents, and then during the summer they stay with the other grandparents, you can incorporate that into your estate plan so those traditions can continue on.
Well, that's interesting. I hadn't thought about that. Very good. All right, question number 12. My daughter's married. If she predeceases her husband, who has children from a prior marriage, how can we make sure that he does not inherit our money?
Yeah, this happens a lot of times. Let's just use the daughter scenario that the parents made the down payment on the house that they're living in, and then she happens to pass away and the house goes to the husband. So that down payment essentially goes directly to the husband, and his children from a prior marriage could be living there in the house, or could inherit it in the future. So there is a way through estate planning, through a trust, to have the money, if it doesn't go to the daughter, go down directly to grandchildren or stay on that side of the family. It's easier to do it with a trust. It's a little bit more awkward with a will, a little bit more involved. But yes, that is definitely doable, and you can designate that assets stay on one side of the family or the other. And you can even designate who your family members are. So sometimes people say, I consider this person, my daughter, even though, we're not related. So you can do that as well.
Mm-hmm. And I think, again, with blended families, that's happening more and more, where, someone remarries, you have children, maybe you both have children from prior marriages, and then you have 1 or 2 additional children yourself, so you could actually be setting up an account or a trust where, wife has a child from a previous marriage and she wants, money going to that child. Husband has 2 kids from a prior child. He wants money going there, and then they have 2 kids together. So you'd almost be setting up 3 trusts in that regard, or in designated how money would flow. And I think that's common to have that sort of planning.
And all of this may sound complicated. We can have the mistrust, and we can set up this trust and that one. The way we do estate planning here at GCPC, we have a flow chart. So as much as we have these big legal documents with all these different terms in it, we break it down in a flow chart so you can see how everything is held now if you happen to be incapacitated or one spouse passes away, and then how things break out into separate trusts. So you can see it in a visual format, and that's also easier to understand.
Excellent. And I was just smiling because with your camera angle, your hands, looked very big all over the screen.
Whoops, sorry about that. I try not to talk with my hands.
There we go. All right. Question 13. My grandson's great, but he struggled with addiction and debt for the past several years. What can we do?
Well, this is a situation where you can put assets in a trust for the grandson, and then the trustee would monitor whether the person is able to accept the assets, or whether they are currently, in a facility or struggling, or they could actually apply to the trustee for certain benefits for certain reasons. They could say, I need, X amount of money for rent for the next 6 months, and the check could be written directly to the landlord, for example. So the trustee could manage that. And this does come into play when parents have, 3 children, and there's just one child who just hasn't gotten on their feet or hasn't found themselves, or we could say they're going down a crooked path, or whatever it is. So everyone wants to treat people the same, treat their children the same, but all of our situations are different. So a trust is one way that you can have certain provisions in there to make sure your money is not wasted, but that the grandson still gets the benefit.
So that could be the spendthrift trust. Is spendthrift trust, would that also work for asset protection? If this grandson's always in debt, does it protect this money from creditors?
It can protect it. And also, that's another situation. If you don't know, obviously 50% of our marriages ended in divorce. So sometimes those trusts can also protect from divorce claims during a divorce proceeding as well. So that's a good point.
Okay, that's depressing. All right, question number 13. Oh, 14, I guess.
We're going to keep this upbeat and not depressing. So we might have to turn this around the next 15 minutes.
No. And we're at 12:45, so we have about another 15 minutes. And if folks have questions, keep them coming. Number 14, we recently purchased a home. Should we update our estate documents?
Yes, absolutely. And it's a perfect time to consider whether you want to have a trust hold your assets or not. And in your will, you want to update that to make sure that this asset is specifically named in your will if and when anything happens to both of you. And of course, we have the situation where sometimes a mortgage is in one spouse's name and not the other. So it's very important to update the estate planning documents with a power of attorney. So if anything happens, the other spouse is able to access all the documents to make sure the mortgage is paid and that mortgage can be managed by another person.
Absolutely. And I think that's, we work with a lot of realtors in that regard. So you move from one state to another, you buy or sell a home, you buy your first home. There are all times where you should consider, doing some of this planning. I think we've already answered question number 15 with the divorced dad and, how you could use a trust to protect some of those assets. So why don't we skip to 16, which is, you have a special needs child. What sort of estate planning options should you consider?
Well, this is twofold. So of course there's special needs trust. So you can actually put finances in a trust and has it designated for your special needs child. And also that allows access to government, often allows access to government benefits and while providing for the special needs child for a facility. However, a special needs trust can also include specific provisions in there. I'm trying not to use my hands. Specific provisions in there to continue the type of education or treatment or care that the child is used to. For example, if the child is used to going to a park 3 times a week, a certain park, you can make sure that that is incorporated into the special needs trust. Or if they like this particular facility that they're in, or if just have anything that they are used to having. Structure is very important for children who have special needs. So you can include those specific provisions in there. It doesn't just have to be a cookie cutter special needs trust.
What is, you often hear about Medicare trust or Medicare, is that part of what you do for a special needs child?
Yeah, it's similar. It's written a different way, but absolutely, it's similar. Most people think about that with older people, but you can. It's an irrevocable trust. So those assets that go in there are designated for that particular person, whether it's an older person or the special needs child, to make sure after you pass away, you wonder what's going to happen, who's going to care for my special needs child, and you make sure that these assets are protected for their care, even if you're not around.
Or for that older person, I guess, you know, and correct me if I'm wrong, so it's a way to diminish their income or assets. So whereas they might not otherwise qualify for Medicare, they would then, because they don't have that income or those assets.
Correct, and it also protects the spouse who is not in need of that, so they can still have their lifestyle, don't have to give up their house, for example, or empty out their savings accounts, because they still have to live on a daily basis. They're not the ones in the hospital or needing treatment. The other spouse is.
Gotcha. All right, question number 17, which is, jumping ahead again, sorry. Is I read that some trusts are used for tax planning purposes. How common is that? And with that, you can also throw in an answer to one of the questions about destiny planning.
Yes.
It has nothing to do with Destiny's Child or Beyonce.
Exactly. Well, right now, the limit is pretty high for estate planning for gift taxes, 11.7 million. But people believe, legislative experts believe, this is going to change and it's going to be reduced in half to about 6 million. So no decisions have been made yet, but it is set to change. So
And is that for an individual or a couple?
That's for individual, yeah. Mm-hmm.
Okay. That's still a lot of money, but okay.
Absolutely, yeah, it's still a lot of money. But even knowing that, you know, the tax laws change all the time, and if you have a trust, you can always adapt your trust to the current scenarios if it's not an irrevocable trust. Plus, we have those charitable remainder trusts that we talk about. You're able to use and enjoy income and assets while giving a future gift to a charity. So during your lifetime, you're enjoying the assets, but after you pass away, you actually are giving the asset to a charity. And during your lifetime, it can decrease your taxable estate. So there's a lot of intricacies there, but it is very common, I guess, to make that full circle. And it's a good idea to work with an attorney in a firm like us that stays on top of all the tax issues.
You know, and it's beyond the scope of what we're talking about here today, but, you know, I think there are probably, you know, dozens of different types of trusts, probably if not more, you know, to accomplish different things, not only tax planning, but other things. I mean, there's a marital trust, and I have a list here. There's charitable remainder trust. There's a qualified personal residence trust, you know, life insurance trust, you know, grantor retained annuity trust, you know, and grantor, it just goes on and on and on. So, you know, for the different scenarios, there are a lot of tools at our disposal to protect assets, you know, and sort of not only protecting the assets, avoid taxes, but have the desires, you know, of the individuals doing the planning fulfilled.
Well, and we said we keep this light, so I'm going to throw in there also are pet trusts, which I have drafted, because some people have pets and they don't, instead of children, and you want to have your pet cared for the way you did during your lifetime. So that's another one.
You know, we have another client that is dealing with parakeets and parrots, and they live, you know, what, 100 years. So you may need to set up something, you know, just to make sure. Although I have to admit, I'm not really a bird person. All right, keep moving.
Okay.
I plan to move when I retire. Should I just wait to do my estate planning after I move? I think we know the answer there.
Yeah, it's no, but I can let you rest assured that most estate plans are portable. I mean, that's a portability clause in them, so meaning that other states do recognize a will or a trust, even if it's not signed under the laws of their own state. So you're not out of the loop. However, every time before you move, it's important to look at your assets and kind of get in a plan going forward. So a plan for growth. So a trust is something that can grow and adapt with your lifetime, use the benefits during your lifetime. So that's something you can look at and make a forward plan for to save yourself problems later.
We had another question here is, can a trust also be challenged in court like a will can be challenged?
Sometimes, often it isn't. So a will can be challenged in court, like you mentioned. However, the way we write wills, we include a no conflicts clause in it. So those clauses basically say to the judge, if this person contests the gift or contests the will, then they are thereby disinherited, or they predecease me. We're going to believe that they predeceased me. So you can have no contest clauses in wills and also in trusts. Trusts are not often brought into probate if they're written and drafted correctly, because they stay private and they don't need any legal intervention, and just the trustee manages it. However, if there is a claim against the trust, it can be, drawn into court. But more often than not, there are a lot of clauses within the trust that says we do not want legal intervention. That's why we created the trust in the first place. So trusts are less likely to be contested, is the short answer.
But in the same way that you might have, you challenge a will for incapacity or undue influence, I imagine you could transfer, or you could contest a trust in the same manner?
Yes, that's true. You could. But again, it's very unlikely, because when you execute a trust, you have the purposes of the trust and the conditions in the trust, and it's very specific to your family. So the judge has a lot to work with by the document itself. So there's less testimony and hearing and evidence that's required.
Gotcha. All right. Question number 19. I'm a small business owner. My family depends on my income. Is the way to protect them with estate planning if anything unfortunate happened to me?
Yes, absolutely. And we touched on it earlier, but one way is through a power of attorney. We can create a customized power of attorney based on the operations of the business. And within that power of attorney, you can designate who would run the business in your absence, but also if the business is going to be sold, who should get shares of the business. And that can be actually reflected in a will or a trust as well. They work in conjunction with each other. Of course, there's lots of different insurance that people can purchase. We don't sell insurance, but that's something that we would advise people. And also looking at the way the accounts are held and who is the signatory for different accounts. So that's something else that we would advise people on.
So I think the answer there is absolutely yes. And, whereas we say everyone should probably be doing some planning, that probably goes tenfold for that business owner, because one of their primary assets is going to be that business, and you want to make sure that you're protecting that business. All right, then. So with 4 minutes to spare, I'm always proud when we go through this and we're finishing right on time. In your years of helping clients with estate planning, what is the most important advice you can give them?
Well, I think the most important advice really is that the law can be used as a tool, and it doesn't have to be just a form document that you download online. All of our families are different. All of our situations are different. Sometimes you have different things that happen in your life, and you think, oh, estate planning is going to be too complicated for me because I have this situation in my life, and that's really not true. We can use law as a customized way to protect your assets. And to avoid conflicts in your family. And estate planning is really a way to communicate your desires, what your wishes are, and what your legacy is going to be. So just as well, communication is obviously the key to relationships, and that's the same is true for estate planning. We try to reflect that healthy communication that protects your money and protects your loved ones and protects yourself through estate planning.
And I think that's sort of that guidance that you can provide. I think is so important. You can go out probably to LegalZoom and get a will or get other documents for $1,000 or however much it is, and oftentimes it might not be that much more expensive to work with an attorney and have that attorney guide you through the process and make sure you're thinking of all the what ifs, which is so important. We have 2 additional questions here.
What?
How can you prevent beneficiaries from having to sell all assets to distribute the proceeds?
Lots of different ways there. There's different ways to hold property. So you can hold property and have a life estate for property, and then have them be able to use and enjoy it, and then pass it on after certain conditions happen. But you can definitely contact me. My email is there and the phone number is there, because that's a little bit more of a specific question. But the short answer is yes, there's a way to do that. But life insurance in that scenario is a good idea to get to if you have a larger property with high property taxes or difficult to maintain. You can use life insurance to cover those debts or to cover those costs if you want to keep things within the family and they all don't have enough money to maintain the particular asset. So twofold, you can do a practical financial way, or you can hold property in a certain way in order to make sure that the assets don't have to be sold.
Yeah, I think it really depends on the assets. If the primary asset of the estate is a 100-acre farm that's worth $1 million, and otherwise there's only a few $1,000s, and you have 4 children, you might not have a choice but to sell the property if you want to give each of them an equal share. But again, you sort of have to think through those possibilities.
Right.
One more question it looks like we have time for, which is, what are your thoughts on trust development via online? Well, I think we've actually already talked about, using online services, which is, you don't get the benefit of an attorney who's done this 1,000 times, who can ask you all the different questions, who can talk to you about different scenarios and help customize the documents.
And also to have a relationship with an attorney when and if something happens. So maybe you have an estate plan, you have it updated with us, and then we keep in touch with you, as the tax laws change, or maybe there's different ways to plan if your life has changed that are better for you. So if you keep in touch, you make sure that the plan is current. So you have a relationship with the attorney, not just us, and use their expertise and their guidance, not just relationship with a form document, right?
Exactly. All right, well, with that, I think we are done. It is 1 o'clock exactly. Actually, it's 1 o'clock and 30 seconds, but thank you, Anne Marie. Thank you, everyone, for attending. If you have any follow-up questions, I know Anne Marie is more than happy to help you out however we can.
And thanks for helping me keep this upbeat, Merritt. I really appreciate it.
All right, thank you, everyone. Take care.